Good evening to all of you who are present today and have joined full day's deliberations on this very interesting topic, which I am confident that must have generated a lot of debate and heat, excitement, enthusiasm. I was amazed by the topic or the theme of discussion as it says, unlocking the billion-dollar opportunity. It is really true. I think this theme itself captures the essence of what must have been discussed. In this context, when the discussion revolved around the fantasy sports and how this activity can be taken forward, what are the challenges which are faced, how they are to be overcome, what measures should be taken in this behalf, and most importantly, why this sports, digital sports you may say, or fantasy sports you may say, online sports you may say, is so important for the growth of the economy. All these aspects raise important issues. We have to keep in mind that this is one activity which is necessary insofar as contribution to the economic growth of the country is concerned. And therefore, what I'm now going to discuss relates to the constitutional aspects of this game of fantasy. Let me tell you, when we talk of the Constitution of India is the supreme law of the land. That means all the laws which are made by the parliament or the state legislatures have to conform to the provisions of this constitution. They are all subordinate to the constitutional provisions. That is why it is also known as Grundnorm. And constitution is the instrument of governance of any nation. Same applies to Indian constitution also. More important thing, if I may state at the beginning itself, for the benefit of all the attendees, because all of you, or rather most of you, may not be student of law or concerned with the legal system, that constitution is a living organ. This is treated as such. It is a living tree, and therefore the hallmark of the constitution lies in its adaptability to the changing times and contexts. As a living tree, its roots are capable of developing various kinds of branches, capable of growing thousands of different leaves on which this entire tree survives or flourishes. That is the nature of the constitution itself. And therefore, I would say that the constitutional system does not lie inert or static. It has to be modified according to the march of time and integrated in a way that better addresses the transformation of any events which take place. And in today's context, we are talking of transformation of digital age. How it has to cater to that, that is the theme of my discussion today. before you. But before that, if I may say so, up to now, the Indian Supreme Court has come up to all these challenges which have been posed before it from time to time. The Constitution, immediately after the independence of the country in 1947, Constituent Assembly was set up to draft this constitution, which consisted of uh, best brains, legal brains, or political brains of that time. They ventured and they labored for 2.5 years, and the constitution was brought into force with effect from 26 January 1950. But if you see from the economic point of view, technology point of view, 1950 was totally different from what it is today in 2021. There's a total change in the lifestyle, total change in the technology. And recent COVID times have ensured in many ways that the technology is not only an instrument of automation, but it has become the instrument of transformation in many aspects. So therefore, in these given circumstances, the challenges of technology, which may bring different kinds of issues before the court and before the Supreme Court or the High Courts, how they meet those challenges is an issue which is being discussed. And it becomes all the more relevant when we talk about this issue in terms of fantasy sport. Let me tell you here a provision in the Constitution. We have a chapter 3, which talks of fundamental rights, and there are various rights which are conferred upon the citizens of this country. The trinity of, apart from many other rights, the trinity of rights which are most cherished are Article 14, Article 19, and Article 21. Article 14 talks of equality. Article 19 gives us certain freedoms. And Article 21 talks about right to life and liberty. And these rights are based on dignity of human being. The right to choice, which flows from the right to dignity, is given to every person, every citizen. And Supreme Court over a period of time has adopted pragmatic approach and dynamic reading of law, and has evolved in so many circumstances under which, as I said, a living instrument or living organ. If I may give you one example, Article 19(1)(a) talks of freedom of speech. Normally, a person would say, when I'm talking to you and I'm talking in this sense, it's a freedom of speech given to me. But what about journalistic freedom, freedom of press? Freedom of press was treated as a part of freedom of speech, so that this becomes a fundamental right for the media or freedom of press. Right to, as I told you, Article 21, which talks of right to life and liberty. Under this, as many as 40 different rights are carved out. Right to privacy, speedy trial, clean environment, right to sleep, right to food, right to education. So if this is the pragmatic approach, how we or where we stand when we talks of the fantasy sports or this activity as a business. Article 19(1)(g) talks of or guarantees or ensures us freedom insofar as carrying on business is concerned. So everybody has fundamental right to carry on business, profession, or a vocation of his or her choice. That is given to us. But then, obviously, the right to freedom this particular freedom, which we are talking about, to do business, doesn't mean absolute right. I cannot, under the garb of right to do business, can indulge in smuggling or can do the business of drug trafficking. These are not permitted. They are prohibited by law. But then how they are authorized? Whereas Article 19(1)(g) gives us freedom to do carry on business. Likewise, we have provision clause 2 of Article 19, which says that there can be reasonable restrictions in the interest of general public, which can be imposed by the lawmakers on citizens. And that is why such kind of activities which I told you are prohibited. And they are treated as reasonable restrictions in the interest of general public. So the two conditions which have to be satisfied primarily, that the restriction which is imposed, which is a restriction on right, a limitation imposed on right, it has to be in general public interest, and then it has to be a reasonable restriction. The word reasonable becomes very, very important here. It is not that, and even if something is in general public interest, you may impose unreasonable restriction. But then it also says that it has to be by law. So it can't be by the executive, by any order you can do it. A law has to be made. But when we talk of the word restriction suggests that it has to be contrasted with prohibition. Whether you can completely prohibit an activity, yes, to limited extent, when it is an unlawful activity, no doubt about it. So in this context, when we talk of online fantasy sports, where we stand. So first, let me tell you where we have entry 34 of the state list in Schedule 7. Let me tell you first thing here, that the laws which are to be made, which the parliament has or the state legislature has power to make the laws, they are stated in 7th schedule to the constitution, which consists of 3 lists where the various subject matters are enumerated. List 1 gives the power, all those entries which are there in list 1, they in respect of those subject matter, it is the parliament which has right to make the law. And likewise, we have list 2, where the state legislature are entitled to make the law in respect of all those subject matters which are stated in list 2. And since it is we are a federal country, though the subject matter which are assigned to the state, even the parliament has no power to make the law, subject to certain limitations which are certain exceptions which are provided in the contract, in the constitution itself. And the subjects which are enumerated in the central list, state has no power. Of course, we have list 3 also, which is concurrent list, where both have the power to make some laws. But when regulation, it comes to the regulation of business of this kind, fantasy sports, because here the thing which is to be seen is, and the entry which becomes relevant in that context when we talk of the constitutional aspects of fantasy sports, is entry 34, which says betting, the subject matter of this is betting and gambling. That means state legislature has power to make laws in respect of betting and gambling. And since betting and gambling are treated as the activities which are not in general public interest, so restrictions can be there on betting and gambling, and these activities can be prohibited also. To that extent, state legislature has power to make it. But the Supreme Court has interpreted this provision as saying drawing a distinction between this distinction between the game of a skill or game of chance, when it becomes betting or when it becomes gambling, only when it is a particular game is a game of chance. But if it is a game of skill and I have to employ my skill to play that game. Like if I give you simple example of all these games, whether it is cricket or badminton, etc. So these are obviously not a game of chance. So nobody can say that these sports activities are, they amount to gambling or they amount to betting. Now, in this context, the question that arises is, and there are many judgments of the Supreme Court which have been given from time to time, distinguishing the game of skill from the game of chance. And if it is a game of skill and it is not betting or gambling, obviously state legislature would not have power under this entry 34 to make law in respect of that, because it talks of betting and gambling. So will this fantasy sports, online fantasy sports fall? Now, fortunately, we have three judgments, at least three of the three high courts, and to some of these judgments, even imprimatur or the authoritatively stamp of approval is put by the Supreme Court also. One is of Bombay High Court, other is of Punjab High Court, Punjab and Haryana, and third is of Rajasthan High Court. And all three have stated in the context of this online fantasy sports itself, which you would be discussing in the next technical session in detail. So I need not go into that, but they have clearly said that this is a game of skill. It is not a game of chance. Therefore, it is not a gambling or it is not a betting. And as I said, the Supreme Court has dismissed at least 2 SLPs, and in recent last month only, against the judgment of Rajasthan High Court, while dismissing the SLP, the Supreme Court has gone to the extent of saying that it is the issue is no more res integra. Res integra means it is not a debatable issue anymore. It has already been settled. So once it is settled, as this position is settled that this is a game of skill, and as I told you, the consequence of that is that that it doesn't fall under entry 34. It is not a betting or gambling, and the state legislature has no power to ban this. Control, regulating an activity is a different thing altogether. But on that also, I would come and would not take much time on that. And I would say, in nutshell, what is the position? In spite of that, the challenges which are still faced by this sport is a matter of concern. It appears that even when there are authoritative pronouncements, some states or state legislatures are still thinking that no, such a game is to be prohibited. They are under a wrong notion that under entry 34 on betting and gambling, they have a right to prohibit. The question that arises is that whether, of course, it can be, if it a particular, as I said, a particular activity is or game is betting or gambling, it can be. But whether the state legislatures have a right to put a legal fiction and treat a game which is judicially pronounced as or determined as a game of skill, but you still, by why I said fiction, legal fiction means, and we call it deeming provision in law, that you treat it by definition, such a game as a game of chance or a betting or gambling, and then prohibit it. This, according to me, is a tall order. And here, of course, there has to be, first of all, change in mindset and of the legislatures. They should be very clear about what is gambling and what is a game of sports, and they should not unnecessarily try to give a golden goose which gives golden egg, and otherwise also the game is not a game of gambling, but a game of sports by labeling it as gambling. Question that arises is that, as I said, first of all, that mindset, and there is a need to clearly distinguish. There may be some sports, online sports, which may be which have the element of gambling, but whether those can be clubbed with the online sports which are under the umbrella of FIFS, and so many members who are, and with such I would say strong or important controls which are exercised in order to ensure that it remains a game of skill and nobody turns into this game into a game of chance or a gambling. In spite of that, whether it should be clubbed, all these should be clubbed together, even when they are, different activities. And in the process, you kill this game, as you have said, which is $1 billion opportunity, and you want to unlock that, that becomes a poser. But on legal side, as I said, if it is a game of skill and if it is not gambling, then per se, entry 34 may not apply. The question would be by, as I said, by creating a fiction, and can you do that? Here, I would say if it's only a prima facie observations which I am making, is that look, as I said, Article 19(1)(g) gives us freedom to do business, which is a fundamental right. Yes, restrictions can be imposed, and as I said earlier, restrictions have to be reasonable restrictions. Now, what is reasonable restriction? Supreme Court has come out with that the yardstick of defining reasonable restrictions, and that is on the touchstone of what we call doctrine of proportionality. And what doctrine of proportionality, if I tell you in nutshell, states, number one, that the activity has to be, the person has to be a fundamental right. Then the law which is enacted should amount to creating a limitation over that or restriction over that activity. But this restriction has to be reasonable. How you say restriction is reasonable, it has to be proportional. And what are the tests of proportionality? Number one, that it was absolutely necessary in the public interest, as I said. But I'm using the expression in doctrine of proportionality, absolutely necessary means there was no other alternative at all but to enact this law, because you are curtailing the freedom of a person. And the intrusion has to be minimal. So these elements are very, very important. And coupled with the fact that the Supreme Court has also laid down another principles in, there's a celebrated judgment in Shreya Singhal, where it is laid down that there can't be any law which can be passed by the legislature which is manifestly arbitrary. So therefore, I think the state legislatures, before stepping in, should realize when the game is treated as game of skill, it's a sports game, it's not a gambling. Whether you can create it or treat it gambling by legal fiction, would it not contravene the doctrine of proportionality? Would it not amount to unreasonable restriction? Would it not be treated as a law which is manifestly arbitrary? So these are some of the issues which arise, and that is where we stand today. And I am hopeful that in the next session, where this, in reference to the case law, etc., where there is going to be by the panel, which is of distinguished persons, they are going to discuss all this. They would discuss threadbare these aspects. And that is what I wanted to say in my introductory remarks. Thank you very much.